Officer video of the October 2025 arrest of Aerin Robinson by Burbank police. Records show the initial stop was for possible drugs and resisting arrest.
Get on your stomach. Want to do it again? Good. No! Hurry!
He is already on the ground, his face is covered in blood, and he is screaming 3 words you have heard before. I can't breathe. The officer standing over him say he is resisting arrest. He says his body physically could not stop moving. One of those people is right. And here is the part that is going to bother you. A judge has already thrown out every criminal charge against this man, and that by itself still does not prove the officers broke the law. Those are 2 completely different questions, and almost every video you have seen about this case blurs them together. So today, we separate them. By the end of this, you will know the one legal standard this entire case turns on, why the video everyone is sharing might be missing the most important 30 seconds, and exactly what to say if your own body or a medical condition ever gets mistaken for resisting. I'm Frank Jacobson. I'm a criminal defense attorney, and on this channel, I don't pick the side that's trending. I tell you what the law actually says, even when it cuts against the person you feel sorry for. I would rather you hear the uncomfortable version from me than learn it the hard way on the side of a road. Here are the facts both sides agree on. October 22nd, 2025. A little after 8 at night in Burbank, California, near the intersection of Buena Vista and Olive. Police say they were called because a man was obstructing traffic, and they mention allegations of drug possession and resisting. That man is Aerin Robinson. Now watch what the body cam actually gives us, and more importantly, what it doesn't. The footage the public has starts in the middle. We do not see the initial stop. We do not see the first words exchanged. We are dropped into the scene with Mr. Robinson already down on the sidewalk and officers already on top of him. I want you to hold on to that, because in a use of force case, the beginning is usually where the whole thing is won or lost. The 30 seconds we can't see often matter more than the 30 seconds we can. What we can see is hard to watch. Robinson is on the ground. There is blood on his face. Officers are trying to control his arms, and at one point you can see a taser come out, and through all of it, he is saying he can't breathe. Here is what his side argues. Robinson and his attorney say what those officers read as fighting them was not fighting at all. It was a medical condition.
Officer video of the October 2025 arrest of Aerin Robinson by Burbank police. Records show the initial stop was for possible drugs and resisting arrest.
Get on your stomach. Want to do it again? Good.
They say his body was jerking in a way he could not control, and that the officers wrongly assumed he was high or drunk. That is his account, and I'll be fair to it. But I'll also be fair to the other side. The officers on that sidewalk did not have a medical chart in their hands. They had a man moving in a way they had to interpret in real time, in the dark, in seconds. And that tension, what his body was doing versus what the officers believed it meant, is the entire case.
Drug use. The next day, me and my daughters, we went to the place to get that handled. So, but it's very disturbing because what.
So let's talk about the law that decides it. The standard for police use of force in this country comes from a 1989 Supreme Court decision called Graham versus Connor. You need one sentence from it. Force is judged by what a reasonable officer would have done with the information they had in that exact moment, not with the perfect slow-motion hindsight we have sitting at home. The court was blunt about this. It said reasonableness has to be judged from the perspective of an officer on the scene, not from the comfort of a desk later. They even admitted that police often have to make split-second decisions in situations that are tense, uncertain, and changing by the second. I know that is not the satisfying answer, but that is the test a court is going to use, and if you don't understand it, you will misread this entire case, and every case like it.
Drugs and resisting arrest.
Get on your stomach. Get on your stomach. Want to do it again? Good. No! Hurry!
So let's apply that test, honestly, to both sides. For the officers, the Graham standard is going to be their entire defense. Their argument is simple. Based on what we perceived in the moment, a man who would not stay still, who we believed was under the influence, near traffic, our response was reasonable. That is not a crazy argument. Courts side with officers on exactly this logic all the time. But Graham cuts both ways, and this is the part their side has to answer. Reasonableness is not frozen at the first second. It updates. As the situation changes, the amount of force that is reasonable changes with it. So the real question becomes this: at what point should a reasonable officer have realized this might be a medical emergency and not active resistance? Because once that switch should have flipped, the math on what is reasonable changes too. And that brings us to the most haunting moment in this whole thing. Robinson later said, and I am quoting his account here, "Thank God I mentioned the word George Floyd, and they lessened the beating." Think about what that claim implies. He is saying the words that finally changed how he was being treated were not medical words. They were two words that made everyone on that sidewalk remember a camera was rolling. I can't tell you what was in anyone's head.
October 2025 arrest of Aerin Robinson by Burbank police. Records show the initial stop was for possible drugs and resisting arrest.
But as a lawyer, that is exactly the kind of statement that ends up at the center of a lawsuit. Now here's the twist that makes this case stand out. Robinson was charged. The DA's office filed real criminal charges against him, a felony count of resisting an executive officer, plus misdemeanor counts of battery on a peace officer and resisting or obstructing. And then a judge looked at the case after a preliminary hearing.
He continues to be targeted.
Robinson's attorney confirms his client has been stopped by at least 2 other police departments and arrested for resisting arrest.
With respect to...
And dismissed it. All of it. Gone. Here is where I have to be the honest one in the room. A dismissal is huge for Robinson, but a criminal case getting dismissed is not the same as a court ruling the officers used excessive force. One is about whether there was enough evidence to convict him of a crime. The other is a separate civil question about whether his rights were violated. Feeling like something was illegal and proving it in court are two different things. He still has to prove the civil case, and he intends to try. His attorney has filed a legal claim. That is the formal step before a lawsuit against a government agency, and they have said they will seek at least $20 million. $20 million. But notice what that actually is: a claim, a demand. It is not a verdict, it is not a settlement, and a number a lawyer announces at a press conference is the opening of a negotiation, not the end of one. I am telling you that because the next channel won't.
The court dismissed everything because, as we understand it, it was a charge of resisting arrest, which, when you look at the videos, they...
Burbank's police department, for their part, says every use of force is reviewed under their policies and the law, and they point out that the case was presented to the L.A. County District Attorney, which independently evaluated it and chose to file charges. Both of those things can be true at the same time. The officers can have followed a process, and a court can still later find the force was too much. That is why we have civil courts. So, was this legal? Here is my honest answer. The initial stop and the decision to use some force may very well land inside what Graham allows. The real fight, the part that actually decides this case, is the middle. Whether a reasonable officer should have recognized a medical crisis and pulled back, that is where this is won or lost. And we may not know for sure until the footage we can't see yet finally comes out. Now let me make this useful for you, because this could be any one of us. If you have a medical condition that affects how your body moves, a seizure disorder, a tremor, diabetes, anything, say it out loud early and say it again. I have a medical condition. I am not resisting. 2, if you can, wear or carry medical identification, because it speaks for you when you can't speak for yourself. 3, the mantra for any encounter: comply physically, assert your rights verbally. You do not win the argument on the sidewalk. You win it later with a lawyer with the footage. And 4, that footage matters. So remember that in most of the country, you have the right to record the police as long as you are not interfering. The camera doesn't get scared, it doesn't forget, and it doesn't change its story on the stand. That, more than anything anyone said that night, is what this case is going to come down to. I'm Frank Jacobson. Know your rights.